Hello and good afternoon, good morning, good evening, depending on where you're joining us from. My name is 𝐮𝐵𝐻𝑚𝐫𝐻𝑚. Welcome to 𝐶M Advocates LLP podcast. This is a podcast where we celebrate professionals, allowing them to come here and share a bit of their industry knowledge with us and our viewers. And with that, today I'm very pleased to have Stella Orengo join me in this podcast to discuss something about the Children Acts. And of course, I will allow her, first of all, to introduce herself before we further go on with today's segment.
Thank you, Susan. Thank you, our viewers and listeners. Today, I'm seated on this other side. Definitely, the hunter has become the hunted. My name is Stella Orengo. I'm an advocate, and I'm here particularly today, to share insights on something called guardianship as it relates to the Children's Act. Thank you for hosting me.
Thank you, Stella. Again, of course, at this podcast, we like to make legal comments on the societal happenings. And over the past few weeks, there have been very sad news about the passing of a legendary Kikuyu gospel singer who goes by the name Betty Bayo. And we have seen what has transpired since then. After the passing, we have seen that various partners, various fathers have come to claim the children, which is a welcome thing, that after the passing of one parent, that the parents would come in to support the children, who of course are in a very sad situation right now. But in those discussions, very interesting legal questions and issues arise on matters of adoption, on matters of guardianship. And Stella is here today to discuss the pertinent question of guardianship. I will pose the question, who is a guardian?
Thank you, Susan. First of all, on the issue at hand, I want to express my condolences to the family of the late musician. We pray that her soul rests in peace. When it comes to guardianship, a guardian will be someone who's appointed by the parents of a child or by court to take on the parental responsibilities of a child. Parental responsibilities means giving the child basic needs like shelter, food, education, having custody over them, and generally being able to make decisions about the child, but always remembering that whatever decisions they make must be in the best interest of the child. Now, they said this is someone who's appointed by court or by the parents themselves. Parents can appoint either using a will or a deed. Mm-hmm. So when I say a will, most people will understand that when you're making a will and saying this property will go to so and so, you can also say this person, in case I pass on, will become the guardian over my children. So that is a will. But by deed, most of us may not understand, but there's something I keep on doing in the practice of law. When you have feuding parents and you do the parental responsibility agreement, I like to tell them, even if you're disagreeing, can we please settle on appointing a guardian? And usually tell both parties, please suggest a guardian. Mm-hmm. But before you suggest this guardian, talk to them, let them understand that you are appointing them as guardians over your children, and this is what it entails to be a guardian. Yeah.
Thank you, Stella. I think also when you're having the conversations about guardianship, a lot of jargon that we use around here is also adoption. Are these two concepts interrelated? Are they different? the concept of adopting an adopting parent and the concept of guardianship, are they two related things? Can they be used interchangeably?
No, yes, we use them interchangeably, but these are two different concepts. Adoption entails that you come in the stead of the parent. So you get all the rights that a biological parent would have over that child. Guardianship is more, you may get certain parental responsibilities, but the child does not become yours. For instance, the child cannot come and say, as of right, I can inherit from the estate of my guardian. But for an adoptive parent, that happens, and we even have adoptive parents getting certificates, birth certificates indicating that they are the parents of this adopted child. So those two are totally different, and even the procedure for carrying out an adoption and a guardianship are different. One is more lengthy than the other. Yes.
Okay. So I would think then the process of adoption would be lengthier because of the rights, of course, that are going to be vested on the parent that is adopting. But that would bring me to the next question, which is, can you act as a guardian for a child who is not resident in Kenya?
No. If you read the Act, it says a guardian can only be appointed for a child who's resident in Kenya. Whether that child was born in Kenya or not is not an issue, but they must be resident in Kenya. And something else, you can also not appoint a guardian who is not a resident of Kenya. So they must be resident. Yes, yes.
That's very interesting. And also I'll ask, just in that context of residents in and out of Kenya, if then subsequently a guardian wants to move out of the country, are they allowed to move out of the country with the child? What happens in that situation, in that context?
So if a guardian wants to get out of the country, out of Kenya with the child, they must go to court and seek what we call leave of court to bring this child out of Kenya. So you cannot just wake up and say, the guardian, we are going to the UK, let's go. No. You have always to go back to court and get leave or permission of court to remove these children or this child from the jurisdiction of Kenya.
Earlier, as you're mentioning and as we were describing the distinction between guardianship and adoption, we said that for adoption, the adopting parent steps in the stead of the biological parent, and therefore the assumption here is that they will take all the rights of that parent, but that does not seem to be the case for guardianship. So the question I would ask is, what are the rights of the surviving parent as to guardianship?
Okay, so that's a good question, and I think it ties into what is happening, the case we mentioned at the beginning.
Yes.
So let's say person A and person B were either married or not married, but appointed a guardian. And then person A dies, and so you still have person B and the guardian surviving them. So both of them can take over the responsibilities, can do jointly, can take over jointly the responsibilities over this child. So they're able to act hand in hand to ensure that the responsibilities and the rights of this child are met. But then you have a situation where what happens if a surviving parent and a guardian have a dispute? The law allows you to go to court and have court pronounce itself on this dispute and say who now takes charge. So usually if there's a dispute between these two persons, the surviving parent and the surviving spouse or the guardian, then just go to court and get that dispute resolved in court. Then we have a situation where if the surviving parent was separated from the deceased parent, and there's a guardian appointed, what happens? So in this case, this guardian or any other person who can show that they have the best interest of the child or children can go to court for court to rule on the fitness and suitability of this surviving parent to be a custodian or to exercise responsibilities and rights over this child. Yes.
Thank you, Stella. And also the other questions that I'm having around this issue is, you said there are two ways in which a guardian can be appointed. One could be by the courts directly and by the consent of a parent. Can a parent withdraw after you've appointed, for the guardians that are appointed through this route of the parent through a deed, exercising a deed to appoint them, can they decide they do not want this guardian and revoke the deed?
Yes.
Yes.
You can actually revoke that appointment. That you're allowed to revoke the appointment, because at the end of the day, you're appointing a guardian who is suitable and who will serve the best interest of the child. So you might appoint someone today and then something changes about them and they are not suitable. Then you have a right to change and replace. And also a guardian can also refuse the appointment. So if they refuse and they were appointed by deed, then you have to replace them. Yes.
In this context also, people understand something. You've seen people designate maybe family members or their friends as godmother and godfather. Is this something that is recognized? Can you attribute that title of godmother and godfather to guardianship? So that the question here will be, can you informally appoint a guardian, or it is just by those two methods?
Because as we said, the law is very clear. It's either by deed, by the parents, or by court. So if you didn't appoint, and if you have godmothers, we do not have something called godmothers and godfathers in the law. But if you informally did that and you have passed on, or both parents have passed on, this godmother and godfather, based on that relationship, can actually move court and ask court to appoint them as guardians over the child or the children. But it's not something they can come and wave and say, I was godmother, so I'm automatically the guardian. But then remember again, we are Africans. And we know very well, even in our villages and estates, when people pass on, relatives will take on, and even nowadays I see friends just taking on the parental responsibilities of our children. That is not wrong. It happens. It happens. But if you want to, there are certain things you cannot do. Like I know people who've done that, but when you want maybe to travel with a child, you can't until you go and get something to show that you're a guardian. If you want them to benefit from certain benefits you get from work, again, you will need the paperwork. So it's usually just important to formalize that relationship and have a document to show that you're a guardian.
Interesting. So in the context of course, this issue now of, unfortunately, the deceased Betty Bio, what would be your parting short remarks? And, of course, taking into account the wrangles that you've seen, the back and forth on social media, the potentially maybe a dispute that will end up in court. What would you advise the viewer who wants to make sure that they do not have this kind of situation playing out? If in the unfortunate scenario that they are survived by their children.
So what for me, and I think let me address it in the context of when you have two parents who are not living together, and both parents are contributing to, let's not even talk about contribution. Remember, a parent, whether you live with your child or not, you have rights over them and you have responsibilities over them. So if you're separated, it's usually important for both of you to agree on who, in case any of you passes on, who becomes the guardian. So that's why I said, like, for me in practice, what I usually do is advise the two parties, please, can each one of you appoint a guardian? Go talk to whoever it is you want. If they're agreeable, come, let's appoint them in the parental responsibility agreement. And then also make the other party aware that on my part, I would want, if I'm not here, for so-and-so to be the guardian. So that if any of the parents die, then the guardian and the surviving parent can both take care of the child, but then they have to agree. So those are some of the things, and that's why you need to appoint people who are also agreeable to your spouse or to the father or mother of your child. So you must also ensure that there's that rapport between the two of them. That's why we say when there's a dispute, then they have to go to court between a surviving parent and a guardian. Then they have to go to court for it to be resolved. That is, if they are not able to resolve the dispute amongst themselves. But remember, the surviving parent still has superior rights over the guardian. Yes? So for me, do it in a deed. I do not like it going to court and having court appoint, because you as a parent know that this person, if I leave my kids under their care, they are likely to take care of their interests, other than if court was to appoint, certain nuances and factors may not come to the attention of court. Though remember also, court considers so many other things. At the end of the day, being guided by best interest of the child to appoint a guardian. Yeah.
So Stella, we've seen a lot of these questions being asked on social media. And I think also the viewers will be interested to know whether it is possible for somebody to adopt your kids or to adopt a person's kids without the knowledge of the biological parent.
No, it is not. Unless the parent can't be found. So that means that the child would have been declared free for adoption using any of those societies that exist. So like in this case, someone cannot come and say, I adopted the child, yet the surviving parent has always been in this child's lives, has not consented, was not aware. So that's not possible. And I would urge, at times we make comments not from a point of knowledge, and they end up being taken as the gospel truth. But the truth is that a parent must consent unless they are not available and can be found, which case then that child will be declared free for adoption by any of these societies that exist. And just tying it back to the issue of the one you raised about godmother and godparents, there's customary adoption. I think that's what usually happens a lot informally. So someone can move court to appoint a guardian under any of the customary traditions and yes, let me call them customary traditions, so that if a certain custom says if a child's parents have died and we can't find anyone to take care of them, this is what usually happens, then someone can say, then maybe I'm a second cousin or a second, third uncle. As per our customs and traditions, I'm entitled to become guardian over this child. Then they can go to court, and court will make an order for guardianship. Yeah.
So that has been our discussion today. It has been a discussion about children and their rights and the intersectionality of these children's rights with family law, succession and succession planning. We have been very privileged to be joined in this discussion by Stella, and that has been our bit. Thank you for watching.